When will an employer own the rights to an employee's invention? This question puts us in the realm of patent law. What it's really asking is, when will an employer own the patent rights to an employee's invention? You might assume, therefore, that the answer would be set out in the Patents Act. However, the Patents Act does not deal specifically with this issue, and we need to rely on common law principles. The only section in the Patents Act which is relevant is Section 15, subsection 1, which simply provides that a patent for an invention may only be granted to the inventor or to a person who would be entitled to have the patent assigned to them. Therefore, an employer who wishes to establish ownership of an employee's invention must demonstrate some sort of entitlement. There are two ways an employer can do this. First, if there are express terms in the contract of employment, or if the employer directed the employee to create the invention in question. If there are no express terms in the contract of employment regarding ownership of inventions, an employer may be able to rely on an implied term. An implied term will exist where the employee was hired to invent, so where they were hired to use their inventive faculty. And this rule was clarified in the case of University of Western Australia against Gray. So, for example, engineers or people who work in research and development, those kinds of employees, they're hired to invent. They're hired to use their inventive faculties. Therefore, their inventions will generally be owned by their employer. Conversely, an employee, such as a sales manager, who is not hired to invent, but does in fact invent something in the course of their employment, then even if their invention is useful to their employer's business and they use their employer's time and resources in developing it, no implied term will exist and the invention will most likely belong to the employee. This is because the employee, well, a sales manager, is not hired to invent. They're not paid to invent. And this principle was settled in the case of Victoria University of Technology against Wilson. This principle was illustrated in the case of Spencer Industries Proprietary Limited against Collins. In that case, the employee, Collins, was a sales manager. His employer, Spencer Industries, was a tyre retreading firm. In the course of his employment, Collins invented an improved device for removing tread from worn tyres. Even though this invention was very useful to his employer, it was held that the invention belonged to Collins, the employee, because he had not been hired to invent. It was not within the scope of his duties to invent. Similarly, in the case of University of Western Australia against Gray, it was held that the employee, Gray, had not been hired to invent, but rather hired to research, and therefore his inventions were his own. This case drew a clear line in the sand between the duty to invent and the duty to research. An implied term will not exist where a person is hired by a university to research. This is because academics are not engaged by universities to advance the commercial purposes of universities. So in summary, if you are advising an employer or an employee, first, you need to look at the contract of employment and see if there are any express terms regarding inventions. If not, there may be an implied term that the invention will be owned by the employer, but generally this is only if the employee was hired to invent.